Hello, everybody, and welcome to another episode of Blood on the Razor Wire TV, where we bring it to you real and we bring it to you raw. Got a special guest today, a federal judge, Judge Sharp. He's coming on. Some of you might have heard about him or seen some of the amazing things that he's done, such as going to the White House with Kim Kardashian and advocating for a man that he was forced to sentence to life. But I'm not going to talk about him too long. I'll let him introduce himself and tell the people who you are, Judge, and talk a little bit about some of the things that you were involved in, some of the things that you had to do.
Yeah, well, thanks for having me on. I've never been accused of not wanting to talk about these things, right? Somebody gives me a platform, I'm going to talk about it. And it's part of why I left the bench. You called me a federal judge. I'm a former federal judge. And it always surprises people. They'll naturally assume that I retired. I did not retire. I stepped down before I was eligible to retire over a catalyst of this being some of the issues that you raised, mandatory minimums and my being forced to sentence someone to life in prison. So when I took the bench, I was nominated by President Obama, and I had been a civil attorney doing civil rights work, employment discrimination, that kind of work, but had not had any experience with the criminal justice system or having been a criminal lawyer. I'd worked on one case right out of law school back in the early 90s, but that was really it. And so when I took the bench, the criminal justice system was really new to me. I understood the basics of it, but not the real important part of it, which is these are human beings. And when I make a decision, somebody's life changes. And not just one somebody, this whole ripple effect of family members and friends and, children, parents, all of that changes. And so what I quickly realized was that the most important thing I am going to do is have control over people's liberty. And that became, when I took the oath of office, swore to uphold and defend the Constitution of the United States. And it's not the first time I had taken that oath. I did it when I joined the military. I did it when I passed the bar and became a licensed attorney. I did it when I worked for Congress. And I did it again when I took the bench. I took that oath very seriously. And so I really internalized all of my responsibilities as it relates to the criminal justice system. And what I found frustrating was then I ran headfirst into mandatory minimums. And I thought, well, wait a minute. Why are you telling me what the sentence is going to be? This whole thing, what do these 3553 factors mean? If you, from thousands of miles away and decades removed from what I'm looking at, how do you know that this is a sentence that's sufficient and not more harsh than necessary? How do you know that this is the right thing to do in this case? Because, when I got a call from, I think my first telephone call was from the Department of Justice saying, the White House would like to meet with you about potentially nominating you as a federal judge. Can you come up here? I was like, yeah, I'll see you tomorrow. But you get vetted by the White House and White House Counsel's office. Then you get sent back over to the Department of Justice. They vet you, but they also investigate you, and the FBI investigates you. And then you get sent over to the Senate Judiciary Committee, who has its own set of investigators, and they investigate you. And then you're questioned publicly, before members of the Senate Judiciary Committee, and then they vote on you. Then it's sent to the full Senate floor. Or actually before that, then the ABA will do their own investigation. And then it's sent to the Senate floor. And I'm confirmed unanimously, and they do that, but it's a Republican Senate, by the way. They do that so that they know someone we're giving a lifetime appointment to has the temperament and the intellect and the judgment to fulfill these duties. Right? These are some of the most important things that are ever going to happen in someone's life. Do I have the intellect, the temperament, and the judgment to do that? Yes, right? The president signs my commission. General Holder signs my commission, and I'm now a federal judge, and they go, yeah, we do think all those things of you, except for the most important thing that you were going to do while you're on the bench, which is sentence someone, a criminal defendant. Well, wait a minute. I don't know if you've ever seen the movie Apocalypse Now. There's a scene where Martin Sheen's character, Captain Willard, is in the little house where Brando, Colonel Kurtz live, and Colonel Kurtz says to Captain Willard, "Are you an assassin?" And Willard says back to the colonel, "No, I'm a soldier." And the colonel says, "You're neither. You're an errand boy sent by a grocer to collect a bill." And I went, oh my God, that's what I am with mandatory minimums. You didn't want any of that stuff. What you want me to do is go collect a bill. I don't want to be Congress's errand boy to go tell someone you're going to serve life in prison when they may not deserve life. And likely, occasionally I would run into a mandatory minimum where I go, yeah, I might have done that anyway, but it was happenstance. There was no correlation. It just worked out that way. But that maybe happened twice. The rest of the time, what I saw were mandatory minimums that were way too harsh for what I was looking at, and particularly where I'm looking at a pre-sentence report. And I now know the history, and I know how this person got here. And so the first one was someone who I had to sentence to a mandatory 15 years on a felon in possession charge. And that was the first one that really hit me, because this young man, he was now 27 years old, his two felonies that caused him to get the mandatory minimum were committed when he was 17 years old. And he pled guilty as an adult, because if he pled guilty as a juvenile, he was going to have to go to a juvenile detention facility. As an adult, he would get probation, and he got probation. Now, fast forward 10 years, where he has changed his life. He's done everything we asked him to do, and he's become an asset to the community, except that he gets pulled over one day, and he's actually his girlfriend is performing oral sex on him, and he slides over the yellow line, and that's why they pull him over. So they did have a reason to pull him over, but once they realized that, that's what was happening, it was kind of, okay, come on, you got to be more careful. Oh, by the way, can we search your car? Sure. And he's got an unloaded pistol up under the front seat, and now he's a felon in possession. And it's 10 years later, and that's a case where I'm looking at going, okay, that was really dumb, but that's not 15 years dumb. What we're doing is taking someone who now had a family and a job and was doing the things we wanted him to do. He was not involved in drugs. He's not drinking. He's a model citizen, except for this one problem. Why do I now want to take a 27-year-old, put him in prison for at least 13 years, right? He's coming out as a 40-year-old man. Now what? Now is he going to slide back into society as if nothing ever happened? And now we've got someone who was an asset, and we've turned him into a liability. And that's the first one that hit me as, my God, what are we doing? But then later, had to sentence on a drug conspiracy case, a young man named Chris Young. And Chris was a minor player in a larger drug conspiracy that involved 33 defendants. But he was a fringe guy. He wasn't part of this, although his conduct did fit into the conspiracy in the legal sense. And he decided to take his case to trial, because the deal that was offered to him, really in spite, because everybody else, the much more culpable players on average were sentenced to about 14 years for this. His offer was 20 years. Well, now at the time, Chris is 21 years old. And, remember back, it's hard for me to do, but I remember back when I was 20, and I'm thinking, when I'm 20 and someone tells me 20 years, that feels like a lifetime. And so when he rejects 20 years and says, I'll take my chances at trial because I'm looking at life, his 20-year-old mind, 21-year-old mind doesn't realize life is life and 20 years is 20 years. The math doesn't make sense. As it turns out, it's all going to have a happy ending, because that's the thing that then leads me to start having my own internal conversation of, is this where I need to be? Sitting on the bench, grumbling about mandatory minimum sentencing and the unfairness of the criminal justice system to people of color in particular, and to people with drug addictions and mental health issues, which is so much of what I saw. And I'm thinking, what the politicians want to do is have the criminal justice system fix an issue that is a societal issue. By the time someone gets to me with drug addictions and mental health issues in an orange jumpsuit and 30-something years old, you can't incarcerate yourself out of this. We got to deal with this back before it happens, or deal with it as it's happening. And so that's where I ended up in my head after 6 years on the bench. Do I sit up here and continue to grouse about the issues I have with criminal justice system, or do I step down? And it really could have gone either way, but I found there was a law firm, they were friends of mine, a law firm out of New York, Sanford Heisler, who said, we want you to come here, and if you do that, we'll give you the platform that you want to speak about these issues. And so I left the bench after only 6 years. And one of the first things that I did was meet Brittany Barnett, who represented Chris Young. And we went in together to work on Chris's clemency application. Now, she had filed a habeas petition, a 2255, on behalf of Chris. And I told her, well, I'll sit down and we'll go through this trial with you. And if I made any mistakes, I'll fall on my sword, right? Because I certainly don't want to do that. And I'm willing to admit if I made that mistake. And hopefully I did. And I was really thinking, hopefully I made a serious enough mistake that we can get this overturned. We couldn't find that, but then started down the clemency path of trying to get this guy out. A life sentence for Chris Young made no sense. It was crazy. And one of the things that really hit me was at Chris's sentencing, after he was found guilty, and he was going to be found guilty, they had the evidence. That really wasn't the issue. So now it was, why are we doing this? But Chris gets the opportunity to allocute, right? And those folks who had their sentence, have been through a sentencing, understand you're going to get to speak to the court. And usually someone will get up there, and sometimes they are saying things that are helpful and profound. Sometimes they're saying, I didn't do it. And sometimes they're angry. And, people have all kinds of different things. And I usually found those helpful in the sentencing process. But Chris got up there and spoke for almost an hour. And he talked about all the things that he would do were he not going to die in prison. And all of the things that he would do or could do if he got out of prison. He knew he was guilty. He admitted he was guilty. What he didn't want to do was die in prison without saying what he felt like he needed to say. And I listened to that and sometimes engaged with him. And he talked about philosophy, and he talked about global economics and world banking and all the books that he had read. And it was heartbreaking. And I realized, oh my God, this young man has so much to offer society. Why are we doing this? Right? This is a kid whose mother was a drug addict, who didn't have a father, and whose brother had committed suicide. He took care of himself when his mother was in and out of jails or prisons. Sometimes they ate out of garbage cans. When their water and electricity had been cut off, nobody realized there were still kids in this house or in this apartment. And he would have to go to a neighbor's house and ask if he can take a shower when he couldn't stand the way he smelled, the way he couldn't stand his own smell. So, right, this made no sense. But here was this young man who was so capable. And that's when it was just, this is bullshit.
Judge, I spent some time with Chris Young in prison, and I can say, not just because of this interview or who Chris is, I can tell you he was one of the most respectful, intelligent dudes that I have ever met in prison. I'm like, this dude is a really good dude. And I knew that, I'm friends with Brittany Barnett. I knew that Brittany was trying to help him. Kim Kardashian was trying to help him. And I was amazed that, like, they're giving out clemency, but he's not on the clemency list. And then I see that you end up going to the White House. You're advocating for him. I didn't know who you were until I read the Matthew Charles thing. And then I think shortly around that time, you and Kevin Ring from FAM had wrote an article for USA Today. You mentioned me in there, and I'm like, this guy right here is a good guy. I was just like, wow. And I kept wondering if Chris was ever going to get out of jail, and it came down to the wire kind of with Chris, whether or not he would get out, right?
Yeah, it was scary. I really thought, we early on, so by September of 2018, Kim Kardashian has gotten involved in this case, and we have been invited to the White House. So it's September 5th, 2018. And I find myself in the Oval Office with Kim Kardashian, Van Jones, Ivanka, Jared, and the President of the United States sitting on the other side of that desk talking about the First Step Act. Because you remember, the First Step Act won't be passed until December of 2018. So there's a lot of conversation and discussion about the importance of signing that piece of legislation. And then we got to talk about Chris Young and Matthew Charles. And I really thought the conversation went so well. I really thought, okay, this is it, man. This is easy. We walk out of here and he signs the papers, and then a year passes and another year passes, and then it's like, oh my God, we're coming down to the wire. Like you said, are we going to get Chris out of here? This is a nonviolent drug offense. What a life sentence. All he's got to do is sign. Let's end this. And he and I, we spoke specifically about Chris, and I just thought this was going to happen, that he was going to do it. And then he didn't. And we just kept on and on and on until that very last day. Alice Johnson called me and said, Chris is made the list. And I was like, thank God you couldn't let this young man die in prison. But it had been 10 years since I sentenced him. Now he's in his 30s. How much more flesh do you want to take from this guy? Now, Matthew Charles, it turns out, didn't have to wait for clemency, because Matthew became the first person released under the First Step Act. And Matthew, I realize your viewers may be going, well, Sharp's all over the place. But let me go back to Matthew. Matthew ended up in front of me on a resentencing after the crack guidelines were changed, right? So it was a Johnson motion that he filed.
It was a horrible case, too. I want the viewers to know that this was shocking, but I'm sorry for interrupting you, Judge.
No. Jump in, because I may get off point here, and if you want to bring me back into the real world. But what happened was that the crack guidelines changed, and Matthew files a Johnson motion to get his sentence reduced. Now, he served 21 years on I think a 34-year sentence. It was in the 30s. I don't remember if it was 34, 35.
I think it was 35.
35 years. And then the question became, was he had been sentenced, he was 21 years in, so he'd been sentenced back in 1994. I was a year out of law school. I didn't know, squat about being a lawyer, and I certainly didn't know anything about crack guidelines. And so he ends up in front of me. He ends up in front of me on his motion because the judge that sentenced him in 1994 has long since retired, Judge Higgins. And I just missed him. Maybe we overlapped a little bit on the bench before he retired. But I get the case, so now it's reassigned to me. And I look at it, and the thing that jumps out at me before I get into the can we do this, the thing that jumps out to me was, should we do this? And the overwhelming answer to that was yes. Matthew Charles has done everything they asked him to do. He didn't have, over 21 years, he did not have one infraction. And he had he would not only had taken his own courses and classes and bettered himself in his education, he was helping others through navigate the system. I mean, this guy was incredible. And so I looked at this and went, I'm not sure that he's actually eligible. But I went back to the sentencing, got the transcript, got somebody to pull the transcript from 94 and let me see how Judge Higgins sentenced him. Because Matthew also qualified as a career criminal. And as a career criminal, he was not eligible for the Johnson reduction because of the crack guidelines. So I go back to Judge Higgins and I'm reading the transcript to see how did he sentence him? Did he sentence him as a career criminal or did he sentence him under the crack guidelines? And he did neither. What Judge Higgins had done was say it doesn't really matter. Whether you're a career criminal or whether it's the crack guidelines, you're still going to get 35 years, sentence imposed as stated. So now I'm looking at it going, yeah, okay, he qualifies as a career criminal, which would disqualify him, but Higgins didn't say that. And if he was sentenced as under the crack guidelines, I think he's entitled. And at the end of the day, what difference does it make? Now back to kind of this Higgins analysis, he deserves to be out. And as part of that resentencing, right, you will state to the court or to the lawyers and the parties, here's what I intend to do. I intend to reduce it or resentence him to time served and let Mr. Charles walk out of here for all the reasons that we talked about. And then when you do that, you ask if there are any objections. And if somebody has an objection to a sentence like that, only the prosecutor is going to object. Do you have an objection? No. He says, no, we do not. And their argument, I really felt like the AUSA, the assistant U.S. attorney who was there, recognized that Matthew needed to be released. I mean, they were there, he was there kind of half-heartedly because he felt like he had to. But they really didn't oppose this. This was kind of okay. Every once in a while, things kind of line up and we think Matthew ought to be released. And so there was no objection. Then my next statement is, okay, sentence imposed as stated, Mr. Charles, you're free to go. And he left. He was done. And he went out and he started working and got himself an apartment. And just like he did when he was on the inside, on the outside, he was doing all those things we asked him to do. Except that AUSA went back upstairs and to the U.S. Attorney's office, and somebody must have said, what the hell are you doing? Appeal that. And they appealed it. 2 years later, so I step off the bench in 2017. Shortly after that, the Sixth Circuit Court of Appeals overturns my resentencing and says, well, you can't do that. He was a career criminal. And so, it really didn't matter what Higgins had done. Okay. But sometimes justice has got to mean something else. It's got to mean doing the right thing. And so it was his release, resentencing was overturned, and he was ordered to go back to prison to serve his remaining 10 years. Right. I felt like,
Want that?
I won't use that. I won't say that way, but I felt terrible. I'm thinking, I don't know that I did Matthew any favors.
Well, you know what? I want that to resonate with people, to realize that Matthew Charles spent 21 years in prison, gets out, he's living a law-abiding life, he's working at that little pantry in Tennessee, he's volunteering, and we have prosecutors that say, you know what? He changed his life in prison, he's out, he's doing the right thing, and we come back to 18 U.S.C. 3553A here in a second, but he's doing the right thing, but we're going to put him back in jail. And they win the appeal, he goes back to jail, and the whole thing, Congress says, federal judges impose a sentence that is sufficient, but not greater than necessary to achieve the goals of sentencing. And one of them goals is rehabilitation. This man's fully rehabilitated, yet we put him back in prison.
Right, because we can. And right, that's the only reason, because we can. And it's one of those things, and I've talked about this before, and it's a problem not just with prosecutors, it's really a problem in the legal system where lawyers never really understood what their role was. And it's particularly important in the criminal justice system where the justice piece of that has to mean something. What happens, and this is why the lawyers, I think, are more nasty than they've ever been, or more difficult to work with, because everything becomes personal to them. And somehow, as an AUSA, or as, you know, a lawyer in a civil case, this is about me, not me representing a position, not me as an officer of the court, which then allows people, at least in their head, to lie and file false documents and perjure themselves because they believe the greater goal is winning, not justice. And so that's how we end up here. It always floored me. Now, fortunately, Matthew became the first person. So that the First Step Act is signed in December, and Matthew is the first person to be released under that act in January of 2019, and he's out. And so I said I felt terrible about. I felt like I had cost Matthew 2 years. As we've got to go back and do another 10 years. At least it would have been 2 years down the road. And so I did have a chance to ask Matthew about it, and he said no. This was fantastic because nobody would have heard of me. You know, had I just denied that motion, Matthew would have gone back to prison and nobody would have heard of him. Instead, it became a national story, and one where Matthew was talked about inside the Oval Office, and is part of the reason why a First Step Act was needed and why it needed to be signed. So, you know, there were some good things that came out of the Trump White House. The list is short, in my opinion, but that was one of them. That was an important thing to happen, and Matthew's out and doing great. I love seeing him and hearing from him to know what he's doing.
You know, that Matthew Charles case is the reason why there should be legislation for second looks and second chances, and this is the reason why the Biden administration should be looking at this type of stuff, because, like you said, you're a federal judge. They say, hey, we're going to vet you, we're going to do all this stuff, but yet we're going to take the power of judging away from you, and you're going to have to go by this chart and, you know, the statutory sentences, and now you're not the judge anymore. They took judging out of judging.
No, but you know what? They didn't get rid of judging. They just moved it, right? Because part of the reason they said, well, we're going to do mandatory sentences because we don't trust judges to use their discretion to fashion the appropriate sentence. So we're going to get rid of discretion and make mandatory minimums. That's not what happened. They just moved the discretion. They took it away from the judges, the third party neutral, and they gave it to the prosecutor, because all of that has to do with how the defendant is charged. And that is back in the prosecutor's side of the ledger. I talk about it this way, and I think it makes it easier for people who aren't in this system to understand. If I'm the umpire, and you know, when Justice Roberts was at his confirmation hearing, you know, he goes, well, judges are just umpires. Well, the Supreme Court's not the umpire. They're not calling balls and strikes. They're setting the strike zone. But for district court judges, a trial judge, you know, really, that's not wrong. We're calling balls and strikes down there, and we have to make sure that we're fair, and we're the third party neutral. What you've done is just taken calling the balls and strikes away from the umpire and given it to the pitcher. Somebody's still got to call balls and strikes, and the pitcher's doing it now. So that's what's another thing that's really wrong with mandatory minimums. The discretion's still there. You just moved it to somebody with a vested interest in having it come out one way or the other, instead of the neutral that you vetted, to make sure this person has the temperament and the intellect and the judgment to judge.
You know,
infuriating.
I'm sorry. Talking about mandatory minimums, there's a lot of young guys watching this show. And you spoke about the gentleman earlier that you had to sentence him to a 15-year mandatory minimum. In New York, some of these guys are out here carrying pistols, and they don't realize that they had a drug charge when they were 17 for even 5 bags of crack. And then when they were 19, they had another drug charge for, you know, maybe an 8-ball of cocaine. And now they get caught with a pistol. And they have to come before the judge, and they might have had another charge. Now they get arrested and they think in New York, I'm just going to get a 2 1/3 to 7 or 1 year in the county. But that's not how it works, because the federal government is picking up these charges now, and they take you over to federal court and they say, hey, you're an ACC offender or you're a career offender. And now you have to impose, and I want them to know this, a mandatory minimum of 15 years. And the prosecution is not into making deals when they're dealing with career offenders where they say, you know what, we'll forget about the ACCA or we'll forget about the career offender stuff and we'll give you an 11C1C plea agreement and we'll give you 7 years. It doesn't work that way. Very seldom, right?
Right. Yeah. You know, if you cooperate, maybe you provide substantial assistance, you're going to have to give something if you want to get out of that. But the number of times I saw that happen where someone would come over, and Chris Young's a perfect example of that. Chris's first 2 drug offenses, the weight of both, offense 1 and offense 2, combined weight was less than a quarter. You know, the coin, it was nothing. Combine those, put a quarter on one side of that scale, and you know, the quarter is the side that sinks. Now that's offenses 1 and 2. Your third strike is life. He's 23 years old and going to life in prison. But the first one, right? The felon in possession, right? The number of times where someone came in and went, well, wait a minute, I've had this drug offense before. I've been picked up with a pistol before. Drugs is really most of the time it happens. I've had drug offenses and always got probation. And this is the exact same conduct. You go, yep. But now you're in the federal system, not the state system. You know, that's not an option. Now you're looking at 15 years, 20 years, 30 years, you know, life, depending on what it is, for the same conduct you've been doing, and not realizing it's a whole new world when you end up in the federal system, and they are not over there, you know, trying to see what's justice in this case. What they're trying to do is see how much time can we give you. You know, when it's changed a little bit, but when Jeff Sessions was the Attorney General, that was his, you know, edict to the frontline U.S. attorneys. I want you to charge them with as much as you possibly can. Stack these things and let's see how much time we can give. This is crazy.
I wanted to ask you that. How many guys came before you that had never done jail time, but they've had the probation, and you had to impose a sentence of 30 years? They've never been to jail before. They've always got out of it, paid a good lawyer in the state, got probation. Now they're in front of you. How many guys?
You know, the number for me to say whether it was, you know, 10, 15, 20, I don't remember the number. I know it happened way more than it should have. And it was frequent. It was frequent that people got over there and just went, oh my God, what? And that would become the argument. So now you've got a defense lawyer up there going, but Judge, you can't give them 20 or 30 years. They've never done time before. Well, and one, that they haven't done time before has nothing to do with it. And 2, I don't have a choice. You just got hit with a mandatory minimum. You know, I don't know what to tell you. Good luck. You know, I don't know what it is. And but part of that too was so frustrating because I was frustrated with the defendant because of that. But more times than not, I'm frustrated with the government and with the system, because for them to end up in that place, in that orange jumpsuit, standing in front of me, waiting to hear what the sentence is going to be, whether it was a mandatory minimum or I'm doing the, you know, 3553 factors. So many times what I saw was someone with a drug addiction or mental health issues, or both, because they were self-medicating their mental health issues with drugs and then became addicted, or their drug addictions led to mental health issues. Nobody cared about that. Nobody was trying to fix that. You know, what happened was you came to me. This person is standing in front of me because of a lack of opportunity, because of a poor transportation system, because of a poor housing system, because of a poor educational system, because of zero mental health and the stigma of drug addiction. And the people over there that could possibly answer and certainly could fund uh, uh, help for addiction issues somehow think that's not their problem, and that if they've just been, tougher or spend a little more time in school or whatever it is, that they wouldn't have these drug problems. Like, man, they didn't go to your school. They didn't live in that neighborhood. There were so many societal issues that led to this person standing here. And Congress, if you think we are going to incarcerate ourselves out of that, you are wrong. You're going to spend the money. You're going to spend that either way. But why not spend it before we end up here? The criminal justice system is rarely justice. That's happenstance. And it is not equipped to fix those problems. And what it does is exacerbates those problems, because 95% of the people incarcerated are coming out. Are they ready for that? Probably not. Do they have the support system for that? Probably not. Do we even know whether they have the support system for that? Probably not. And I ran into that personally when there was a man in the state system who appeared in front of me on a 1983 civil rights violations. He had sued the private prison that was housing him because they had, in his allegations were, and I listened to the evidence, I believe this to be the case, that the guards were working with a gang in the state prison. Somehow the gang, it was never clear to me what the gang's problem was with this man. Nobody really ever testified to that. There was some rumor about it over cigarettes, but this guy didn't smoke, so I'm not sure what all that was about. It didn't really matter. The guards let them into his pod, and then they opened up the door to his cell and let them in the cell, and then ignored what was happening in this small space while he was beaten and stabbed and almost died. Well, had to be life flighted to Vanderbilt. On the stand, he said, I always wanted to fly in a helicopter, but I never thought it would be like this. And it was like, the entire courtroom was crying over that one. It was just heartbreaking. But he lost that trial. And as I was stepping down off the bench, and I used to talk about him, and people would wonder how he was doing. My staff talked about him. Everybody was so impressed with this man that as I was stepping down off the bench, I asked my courtroom deputy to find him. I knew he had been moved, and so she looked him up, and we found the prison that he was in, and I wrote to him and said, I'm stepping off the bench. But I was really impressed the way you handled yourself in the courtroom and your intellect and your abilities. If there's ever anything I can do for you, please let me know. And I heard from him almost immediately and said he was up for parole for his 6th time. He'd been denied 5 times. Would I come and speak on his behalf? And so I drove turned out to be about 6 hours. I got to the prison and attended his parole hearing, and he was paroled. And so he's out. But one of the things about that, what led me to tell you this story, is what I hadn't thought about was how difficult it was going to be once he got out without a support system. I was able to find a job for him, but the job wasn't close to the halfway house where they put him. The halfway house was in no way, shape, or form a place that was going to help him reintegrate. It was actually a hindrance to trying to reintegrate and reenter society. Without a car, he was dependent on a bus system that in Nashville, Tennessee is not the best. And so it was difficult for him to get anywhere on time. And it just became so hard to do what you were supposed to do. And the easy thing to do would have been to, let's go make some quick money. At least I'll have some cash and do something illegal. But he didn't. He kept at it in spite of the obstacles that were thrown in his way, and eventually started his own small business and moved back home to Memphis, and he's doing well. But it was difficult. And gosh, if you don't have a federal judge who can make a call and say, let's get this guy a job, or hey, let's go find you a car. If you don't have those people there, I don't know what you do. Except struggle. And so, it's all of this. And the world at large, society at large, doesn't want to talk about that, and they don't want to acknowledge that this is all of our problems. This is not a bad neighborhood problem. This is not a black kid problem. This is all of our problems, and we've got to work to solve it. And this is not, listen to the do-gooder, left-wing socialist judge. That's not me. I'm about as middle of the road as they come. I'm a guy who can look at the landscape and go, we got to fix this. Somebody's going to have to. We can do it, or we can leave it for our kids or our grandkids until this thing crumbles. But we can't do nothing is not an option.
100%. I agree with you on that. Right now, now that you stepped off the bench, I want to talk a little bit about Leonard Peltier. You're representing Leonard. I mean, very high-profile case. I've done some research on the case. I've read it over the years. I think there was a book that he may have wrote or someone wrote about him, and I read that. Big discovery violation in the case, and he still doesn't win. Yeah. And you're fighting to get Leonard out of jail. How long has he been in prison?
Actually, today's the 8th, 46 years yesterday. 46 years yesterday. He is 77 years old. And this case was so riddled with constitutional violations, inappropriate misconduct in the investigation and the prosecution of this case. That's part of, what I talked earlier about having taken these oaths of office when I swore to protect and defend the Constitution of the United States. So did the agents and the prosecutor in Leonard's case. They did too. And then they fabricated evidence. And then they hid Brady exculpatory evidence. And then they threatened and intimidated witnesses. And I did an interview on CBS a couple of days ago. And the anchor who was interviewing me read to me a statement from the FBI. And it said, well, Leonard's conviction has been upheld by every court that's taken a look at it. But you know what they didn't say is that we didn't do those things. They never denied doing the things that I see in the record. I mean, that's part of what happened when the story came out that I was in the White House and got to tag along with Kim to that meeting. Someone saw that and said, well, maybe he can bring some attention to Leonard Peltier's case. Leonard was a Native American. He was part of the American Indian movement, was involved in a firefight with what turned out to be FBI agents who were in plain clothes and unmarked cars. Leonard was prosecuted for killing the agents. And what they used is really the only piece of evidence was a shell casing that matched the weapon that Leonard had. Nobody questions that Leonard was there. There are about 40 people. You have to kind of go back through. It'll take way too long to describe the context of why the American Indian movement was at the Pine Ridge Reservation in 1975. But they were there to protect the citizens, what was known as the Reign of Terror. The federal government was working with a private militia group, and there had been 60 murders in the area of AIM members and AIM supporters. And so they were there to protect the traditional Indians. One day, 2 agents drove up onto the reservation ostensibly to serve a warrant for the arrest of a young man for stealing a pair of cowboy boots. The place was a powder keg. Somebody shot first, and then bullets started flying. 2 agents were killed, and a young native kid named Joe Stuntz was killed. He was 21 years old. He was shot in the head by a federal agent. Never investigated. We don't know who shot him or why. Was that person threatened, or was Joe just standing there and an easy target? No one ever asked. But they prosecuted Leonard for killing these 2 agents, and they used the shell casing as their evidence, and said, we would have liked to have had a firing pin test that would have been much more accurate, and it would have told us whether or not that was Leonard's weapon or not, but we couldn't because the weapon had been destroyed. And so that's their case. They had threatened some other young boys who were 15, 16 years old at the time. They had testimony that would have been harmful to Leonard. But it turned out that they later recanted all of that and said they had been threatened by the FBI and the BIA, the Bureau of Indian Affairs officers, and that none of that was true. And they recanted that testimony. The judge didn't let in any of the context of the reign of terror. And so essentially it was Leonard against the shell case. There was also a juror who admitted to being prejudiced against Native Americans, allowed to stay on the jury. What in the world? I mean, I guess it's 1977 by the time he was tried. You just did whatever the hell you wanted to do. That would never pass muster today. But it turns out, so that was their case. Here's the shell casing. Here's the guy. We know he was there. Here's shell casing from a weapon that is similar to his, and it was found right there at the scene. Wish we'd been able to do a firing pin test. Turns out they did do a firing pin test, and it wasn't Leonard's weapon. They hid it. This was a blatant Brady violation that was discovered several years later.
How do you not win that? How do you not win that?
Right. Mike Flynn won his case, and the Brady violation was much less egregious. And I supported Mike Flynn. I signed on to an amicus brief that said, look, if you're failing to turn over Brady evidence, you just lose. It's a constitutional violation. You want to try this thing again? Do it. But you can't do this. But they withheld exculpatory ballistics evidence. And so now there's one other piece to this, that Leonard's co-defendants who were tried separately were acquitted based on self-defense. So then Leonard is tried. None of the evidence of the acquittal of his co-defendants gets in. None of the reign of terror information gets in. None of the evidence of the threats and intimidation against witnesses who had since recanted gets in. They knew that the witnesses had recanted before the trial. So all of that was there. They should have been able to question them about that prior testimony. That's how they got the indictments from the grand jury, by this perjured testimony. They should have been able to ask about that. They weren't. But Leonard is convicted of killing them. But it turns out, right, once the ballistics evidence is discovered, now the U.S. Attorney's Office has a problem. And they then admit, we don't know who killed the agents. But Leonard was there, and so aiding and abetting. Okay, but that was not your theory. Did the jury convict him of aiding and abetting? No. They convicted him of assassinating two people, which is what you argued.
They convicted him as the principal, right?
Right.
And now we find out, no, he was just there.
Right. He was there. And, the standard on review was different then, right? So the standard today would be, did you receive a fair trial in the absence of this exculpatory evidence? Then the standard was, would the jury probably have made a different decision had they seen the exculpatory evidence? Well, the Court of Appeals says, well, they possibly could have, but we can't say probably, and so we're going to uphold it. And so the conviction stands. Judge Heaney, who wrote the opinion for the Eighth Circuit Court of Appeals, later came out and said, Leonard Peltier deserves clemency. The federal government needs to take responsibility for their role in what happened there. Leonard has served, at that time, he was in the 25, 30-year range, maybe 25-year range. And, Judge Heaney said it's time. We can't heal the rift with the Native American community. And there's no question, another Court of Appeals said this too, there is no question that the government engaged in misconduct in the investigation and prosecution of this trial. Their position is, the government's position is, well, so what? It was upheld. Yes, in 1970s, it was upheld. You could get away with that. But that's not how it works now. There's another piece of the evidence. So Leonard went to Canada. After the firefight, Leonard fled to Canada. And the Canadians wouldn't extradite him because they said there's no evidence he did this. So we're not extraditing. The government needed a witness, and they found one, a woman named Myrtle Pourbaix, who signed an affidavit that said, I'm Leonard's girlfriend. I was there that day. I saw him kill the agents. Okay. Now the Canadian government says, all right, the courts, looks like you've got evidence. We're going to extradite him. Turns out Myrtle Pourbaix never met Leonard. She wasn't there that day. She saw none of this. She didn't know who Leonard was, never seen him before until she was in the courtroom. And the Canadian court wanted to know what was going on because it obviously turned out that entire affidavit was a lie. And the then U.S. attorney said, well, we don't know how this happened. We agree there's not one scintilla of truth in this affidavit, but that affidavit was drafted by her, quote, FBI controllers. Wait a minute. That's not how this works. I have been in that arena, and I know the U.S. attorney doesn't take an FBI affidavit and just file it. They help draft it. They vet it, right? They're part of this.
She didn't just show up down there and say, she didn't just show up and say, hey, I want to give a statement, right?
Yeah, right. So, to blame that on the FBI, that's not how this works. You were part of it. Now, the interesting thing that happens is that years later, in the 1990s, 60 Minutes does a story on this. And Steve Croft specifically asked the AUSA, in this case, a guy named Crooks, did you know the Myrtle Pourbaix affidavit was a lie? And he says, no, I didn't. But then he says, but so what if I did? It doesn't bother my conscience one whit. He doesn't, this is not hypothetical. He says, so what if I did? It does not bother my conscience one whit. He admitted it on national television. He knew that affidavit was false, and they filed it with a court. If that happened today, he possibly gets disbarred. He certainly gets disciplined and probably never works for the U.S. Attorney's Office again.
So you're at the point now with Leonard Peltier, right, where he's got a clemency petition in, and I'm going to ask all the viewers, I'm going to post it in the description, to write a letter of support supporting his release. What do you think? Yeah. Do you think at 77 years old, after 46 years in prison, numerous discovery violations, the U.S. Attorney's Office not being truthful, agents not being truthful, do you think he's going to end up getting relief?
I think so. I think so, because if enough people, there's a constituency, right? The FBI is obviously against this, and I get that. They shouldn't be, because what was happening in 1975 was the remnants of a Hoover FBI. If you were no longer a Hoover FBI, and I agree with you, I don't think you are, in spite of the issues that we still see pop up, this isn't Hoover's FBI, except that it is Hoover's FBI as long as Leonard Peltier is in prison. You've got to break from Hoover, and that's what does it. This is all part of COINTELPRO, which you could take for another hour and talk about COINTELPRO and this organization within the FBI that ran counterintelligence operations against domestic groups that they believed to be subversive, including Martin Luther King and the Student Nonviolent Movement. And, American Indian Movement was part of that. Black Panthers were part of that. This is all part of the COINTELPRO. They need to break from that. But the other thing that's happened is the president needs to understand there's a constituency that cares about this. They care about the Constitution. They care about the relationship with the Native American communities. I think we're just now starting to really understand that, or at least be willing to talk about it. And that's an important group. It's an important group to the president, and the mainstream Americans are starting to understand the severe mistreatment of the Native community. We're also learning about these boarding schools where kids were literally kidnapped. Our mainstream America is learning about them. I learned about it as part of this process. That I thought this ended back in the 1800s, but Indian children would be taken from their families, and the motto of this organization was "Kill the Indian, save the man." They would cut their hair. They would prevent them from speaking their language. They would be beaten if you were caught speaking your own language. Thank God it didn't work, because we wouldn't have Navajo code talkers in the Second World War if they had been able to have them lose their languages. But that was part of the process. get the Indian out of them. They thought of them as savages. And I thought that was 200 years ago. It wasn't. These organizations existed through the 1950s. And Leonard, at 9 years old, and his younger sister, Betty Ann, who was 6, were both taken, along with a cousin. His grandmother had gone to the government for help. They needed food and clothing for the kids. And instead of getting help, they took the kids and took them to one of these boarding schools. And so as mainstream America starts to learn about that, I think the support, and we now understand why Leonard was there that day. We understand why that area was a powder keg. And we understand that we've got to move beyond that. And the way to do that is to grant clemency after 46 years of a 77-year-old man who's had open heart surgery. He's got diabetes. He's got hypertension. He's got an aortic aneurysm. This is a sick old man. Enough is enough. It's time to end this. And I think there's a constituency for it if the president hears from him. And that's why your offer is so critical to his movement. The White House needs to hear that mainstream America, all Americans need and want this to happen. But also write your representatives and senators, because they're coming on board and the White House cares what the members think. And so when Patrick Leahy came out with a public statement in support and then wrote a letter, and Senator Schatz from Hawaii came out and wrote a letter to the president, and other members, Deb Haaland, who's now Secretary of the Interior, wrote, and Representative Grahala wrote a couple of years ago. So it's important, and the members need to hear from your listeners, and the White House certainly needs to hear from them. They can write, they can post a comment on the White House website, they can call. There's somebody at the White House who will answer that phone. Not always, but a couple of days a week, somebody will answer it and they'll take your comments down. You can email the White House. So any of those doesn't have to be hard, and you don't have to say much except free Leonard Peltier. It's time. Enough is enough.
I'm definitely going to put it in the description and ask people. And, Judge, I appreciate you coming on the show. I'm going to get ready to close the show, but definitely appreciate you. Definitely appreciate your view. And I want people to understand that, the federal government doesn't play games. That there's a young man out there watching this show today that might have 2 prior felonies that was on probation. And he's got a pistol. And I want him to think about it. And I want him to think, man, I probably should get rid of this because my mandatory minimum could be 15 years. He heard from a federal judge that said you could end up with 30 years in prison. You could be like Chris Young. And, and I felt that when you were talking about it when he got sentenced, because I remember what it was like when, I was sentenced. I was 24 years old, sentenced to 40 years, and it hurts, it hurts. And I don't want to see these young guys standing in front of a federal judge that has no discretion as of now because of mandatory minimums, and the judge has to say, I'm giving you 40 years. So hopefully
it is heartbreaking. It's heartbreaking for everybody. There's a mother sitting out in the gallery who's going to be crying because she is not going to see this person. And who knows where you're going to be housed, right? If you get sent to a max prison, where are you? Thousands of miles away from home. There ain't nobody visiting. They can't.
I was from New York, and my first prison was USP Big Sandy. I mean, I don't know how. That's pretty far from New York. I think it was a 12-hour drive, and I seen my mother one time in 8 years, and I finally seen her when I got moved back to New York. But this is all part of being a drug dealer, all part of carrying a gun or committing robberies. It's the part that you don't want to be a part of. So
get there, and there's help out there. You don't have to look for some help. Somebody to help you. Your show is great for that, giving these guys this information. Thank you for doing this show. Thanks for having me on.
Thank you. I'm going to close the show and tell people to, hit the subscribe button, share the video. This is an important video. The description about Leonard Peltier will be in the comments and everything. So please write some letters, make some phone calls. We appreciate you. Until tomorrow, we're out of here.